I have it. This I'm going by the law, Your Honor. I'm not just making
No,
up
you're not
anything.
going by the law. You're making up the law as you go along. You're not going to make a mockery of the judicial system, which is what you're attempting to do. You're
That
also not going to waste this court's time and resources on cases, on arguments that are invalid. I'm not
that
wasting any more time on it. We are done. All right, Mr. Chavez, can you turn on your camera and tell me your name?
Chavez, Your Honor.
There you go. All right. So Mr. Chavez, do you have all of that now?
No, like he said, I didn't. After 10 days, he just said.
Today, we're looking at another court hearing involving a self-proclaimed sovereign citizen. This time, the case is about something many adults have dealt with at some point: credit card debt. Instead of addressing the situation directly, this man spends the entire hearing insisting the credit card company doesn't exist in the way we think, and that the court has no authority over him because he's a living man. The judge, however, isn't having any of it. She keeps pulling the conversation back to the actual legal matter, but he refuses to budge. It's hard to imagine how anyone still believes that "I don't consent" can erase a debt. You can see right away that he's trying to avoid responsibility. Somehow, he even turns the case into a claim that the bank owes him money.
I mean, I could check my email, but I haven't received anything from him.
Did you receive all the documents you requested?
No.
Mr. Royce, when were they sent?
They were sent all documents except for he had requested internal accounting records of Chase Bank, just generally, not specific. But the Chase Bank record relative to his account statements were provided.
Okay. So, Mr. Chavez, what is the defense on this case? What is your defense?
Well, I needed to see one of the documents. Well, my defense is that, I've been researching the law and, the powers of the banks. And it's more of a accuracy of the actual accounting that I'm trying to make sure, and make sure that everything is accurate. So it's not my intent to not pay anything, but I need to know, based off the accounting, that I am paying what I'm supposed to be paying. And based off of what they're saying,
your last payment, back on 5/15/23, you owe $3,398.36. And they're coming for $3,398.36. That was the balance on the card at that time.
Like, that's why I asked questions, Your Honor. You say you gave them 10 days to send it to me. They didn't send it to me. I just got an email this morning.
You're not disputing that you had the card, right?
But that's not the issue at hand, is what I'm saying.
No, it is the issue at hand. The issue at hand is, did you have a credit card? Did you use money on that card? And did you not pay the card off? That's the only question.
Right.
Those are the questions.
Okay, my defense is I am the lender and they borrowed from me.
What did they borrow from you?
My personal security, which I'm entitled to rights to.
No, I'm not buying that. No. Listen to me. Listen.
It's not about. I have it. I'm going by the law, Your Honor. I'm not just making up anything.
No, you're not going by the law. You're making up the law as you go along. You took a credit card on. You agreed with that.
The charges on the card were his, but he's acting like he's the creditor and the bank is the debtor. It's like someone eating at a restaurant, refusing to pay, and then asking the chef for money instead. Whether he truly believes what he's saying or is just trying to avoid repayment is anyone's guess. That was the end of his first hearing, and it was difficult to watch. Reasoning with him was like trying to convince someone who's determined not to listen. But I'll admit, I'm curious to see what happens next. So, we'll move on to the next hearing. In the follow-up, the judge handles things calmly and firmly. This isn't the most extreme, sovereign citizen case out there.
And then you had a credit card. You used the credit card. You have a balance on the card, and you didn't pay on the card. They don't owe you anything.
So so when I asked for the application, the evidence that opened up the account, because they go by GAAP accounting principles. If my application opened up the account, that means there will be a credit on my account because that's a cash equivalent. That's what the law says.
All right. Yeah, motion for summary disposition, hearing date will be January 9th to 25th. And the motions to be filed forthwith, and a copy obviously is to be provided to Mr. Chavez. And we'll see you back on January 9th, 2025 at 9:30 a.m. for the hearing.
Thank you, Your Honor.
All right, we're all set. All right, and I've got Mr. Chavez back. Do I have Discover Bank still?
Yes, Your Honor.
All right, Mr. Chavez, can you turn on your camera and your microphone, please, sir?
But it's clear he has created his own version of reality. Credit card debt is serious. It adds up quickly. That's why most people facing it try to work out a payment plan or get legal advice. If he had simply told the court, "I can't pay this right now can we arrange something?" he might have left with a manageable plan. Instead, he argued that the bank was the one in debt to him. Without solid legal advice or basic common sense, he's only made things worse. So,
all right, we're back on 24010674, the Discover Bank versus Arnold Chavez. All right, and I know that we had a previous court date on this on October 10th, and the default was filed, and then an objection was filed timely on this case. So we're here to set aside the judgment. What's your motion, Mr. Chavez?
Well, that day, Xfinity, I have Xfinity internet, and they was working in my area. And I have proof of. I talked to them in the chat. They confirmed it, and I have they gave me a bill credit for the inconvenience, so that's why I wasn't able to attend because I was having problems with my internet.
All right, and just so you know, Mr. Gopal, we did have notice that he had contacted the court and that he was unable to get on that day.
Oh, he contacted the court on October 10th?
I'm not sure if it was on October 10th, but it was shortly thereafter. If it wasn't October 10th, that he was having internet issues and could not get on. So here's what we're doing. I'm assuming, Mr. Chavez, do you have a defense on this case?
I just want to go through the due process.
Okay. All right. Here's what we're going to do. Arnold indicates that he does not dispute that the card was taken out. The only dispute he appears to have is that a few paragraphs here, he does not agree with the fact that by virtue of defendant's default and breach, the entire balance of the account is now due, and these statements were attached, that the contract and or monthly statements are written instruments, evidence indebtedness with a specified interest rate, and that he disputes whether or not it's an account stated. It clearly is. It's the original creditor. There's no sort of defense regarding assignment on this case. The balance at the time of the complaint was $4,378.29.
Well, I have affidavits that support what I'm saying, but I will want to enter into this as evidence.
The motion for summary disposition is granted sua sponte by this court. There is no valid defense to this claim, and
I couldn't even enter any evidence.
And a judgment in the amount of what is claimed in the complaint, $4,378.29, will be entered by this court, and documents can be submitted for that purpose. And officer, I have a few more documents for that, and we're all set. All right, we're all set. Thank you, Mr.
No words.
Mr. Arnold, I have ruled against you.
I
I
have
am allowed to
evidence.
do so on the court rules. You filed an answer. It's the appropriate response to this. You're not going to make a mockery of the judicial system, which is what you're attempting to do. You're also not going to waste this court's time and resources on cases, on arguments that are invalid. I'm not wasting any more time on it. We are done. Thank you.
Thank you, Your Honor.
What did you think of these hearings? Did the judge handle him appropriately, or should she have been tougher? If you enjoy seeing real-life courtroom moments where the law prevails over questionable arguments, stick around for more. I post new cases daily, and your support means a lot.